since the history of my practice of as a lawyer in this country. As a matter of fact, there's no legal jurisprudence, there's no legal decision, there's no decided authority that authorizes a state to appeal, to file appeal of this nation. Because the law is right and clear. When a citizen who is being prosecuted or who is being, prosecuted on a criminal matter is discharged in the circumstance in which Nnamdi Kanu was discharged, amounting to acquittal, the person will naturally, assuming the person was in court on the day the pronouncement was made by the court, walk free from that court without being interrupted, intercepted, or arrested by anybody, sent to his house. This is the system. This is how it operates. I've never seen where a court will say we decide that someone has no case to answer, or someone is discharged and acquitted, then the person, a government prosecuting, will appeal. And on top of that, continue to detain the person. It hasn't happened. Now, a charge was brought against him before the Federal High Court. On application, led by Professor Michael Zekome's team, the court struck out 8-count charge out of the 15-count charge. Unsatisfied with many counts, an appeal was filed against the many 7-count charge. Federal government responded. The appeal was argued on the merits, and the court upheld our appeal and consequently struck out the many 7-count charge. The court did not only struck out the many count charge, the court discharged Nnamdi Kanu of any further indictment. Even after striking out that 7-count charge, the court proceeded to rule to direct the federal government to release him unconditionally. The court further proceeded to direct the federal government not to entertain, not to file any charge or indictment against Nnamdi Kanu in any court in Nigeria. Ordinarily, what's expected in the circumstance is for the federal government to comply with the order of the court. Without further ado, but it's important for me to also mention that when this was going on, when that judgment was delivered, the federal government took 2 far-reaching steps to circumvent the judgment delivered by the Court of Appeal. One, on that day the judgment was delivered, being 13th of October 2022, the federal government went to State Court, Federal High Court, and filed a fresh charge against Nnamdi Kanu. And when this fresh charge was filed against him, it was given to the press to announce in their usual manner, and it was widely published. We are not served with this charge. Now, 2, they filed an application to stay execution of judgment delivered by the Court of Appeal. So, on the following day, when the matter was slated for a report of the outcome of the proceeding before the Court of Appeal, the following week, we went to court. Then the court was also giving the judgment of the Court of Appeal that said, you should not be tried before any court. You should not be further detained. It should be released unconditionally. Then the court said, I don't have jurisdiction to entertain the charge. Okay, let us have the charge. They didn't serve the charge. And the court consequently struck out that fresh charge they filed against him. That is number 1. Number 2, they filed an application to stay the execution of the judgment of the Court of Appeal. And I've mentioned it here. I've said it in several forums. I've also said it in various Nigerian media houses. That there's no legal authority, both statutory laws or case laws, that authorize the staying the execution of a judgment that's discharged and in the circumstance of that judgment acquitted a citizen of crimes indictment against him. This an application to stay the execution of the judgment was purely predicated on civil provisions of the Court of Appeal rules. Civil provision of the Court of Appeal rules. No criminal provision, because what we're talking about is criminal proceedings before the Court of Appeal. And court sitting by presided over by a different panel this time around, granted this unprecedented order. Still the execution of the Court of Appeal. We then proceeded. The appeal against the judgment of the Court of Appeal Then the court, on a different panel, now before a different panel, the court granted the order, staying the execution of Court of Appeal. Now, when this was done, the federal government went to sleep. They practically abandoned the appeal before the Supreme Court. They didn't file the appellate brief within the time specified by the same court. That court that granted order had a time limit within which the federal government is to file the appellate brief and transmit record. They didn't file the appellate brief. As a matter of fact, the transmit of records to Supreme Court was done at our own prompting, because they abandoned everything and left. Because what their intention is to keep Nnamdi Kanu to pursue detention before the NSSS. The compilation of the record of the Court of Appeal to Supreme Court was done at our own prompting. They didn't file appellate brief within the time stated in the ruling delivered by the Court of Appeal. It took our application to get that appeal dismissed. Before they can even attempt to file an appellate brief. And when this appellate brief was filed, they hid it from us, they didn't serve us, we didn't even know about it. It was when we are following up on a day to hear this application for the dismissal of that appeal that it was brought our attention that they filed appellate brief for a period of time and weekly applied for certified full copy. In fact, as a matter of fact, as sounds today before judgment being coming up next week, our government didn't serve us the appellate brief the first file. They didn't serve us that process because we got it via an application for certified true copy to use of the Supreme Court before we were able to be given a copy of what they filed. And we responded. All this we articulated in process before the Supreme Court, and was exhaustively argued by Professor Michael Sekome during the address. So, when the matter came up for hearing, we have a lot of applications, so many applications before the Supreme Court. One for transfer to a correctional center pending determination of the appeal. 2, bail. 3, for medical for doctors just to see him. So this application, in line with the extant rules of the court and practice, we are all disposed of. Then, and also an application for extension of time to file their appellate, which they file out of time, and also an application to regularize what they filed. So on that day, they also came up with another application, which was served on us a day before the date set for the hearing. What's this application about? Application to amend their grounds of appeal, and also to deem the grounds of appeal amended as properly filed and start. When we look at this application before the court, let us take Professor Michael Zekome also. After we put our heads together, we understand that the essence of what they're doing is to buy time. It's to buy time, because there was no difference between what they filed before and what they're asking the court to amend for what they're seeking court to amend. It's just to buy time. And we said, no problem. Go on. We're not opposing. Go on. We're not opposing the application. So we can be able to put in our response, amend our response to accommodate to what them, to reflect our direct response to what they filed. So that was done, and the matter was adjourned for hearing. On the date he came up for hearing, they told the court that they were unable to respond to our reply brief, despite the fact that they have sufficient time to do that. Even while coming to court, they came with a draft copy of what they have. Let us say Professor Michael Zekome, all the court allowed them a standard to enable them filing, to file what they have in court. They said, no, even if a standard is granted, they cannot be able to file all this process. They want to time. So the matter was adjourned for